cannot be said to be a system governed by the rule of law. It is instead a system where the strong will prevail over the weak, where the rich will prevail over the poor, where members of the dominant group will prevail over the members of minority groups, regardless of what the law provides for. In other words, judicial independence guarantees compliance with another core component of the rule of law, the principle of equality before the law, which, to borrow from Dicey, means that every man, whatever be his rank or condition, is subject to the ordinary law of the realm and amenable to the jurisdiction of the ordinary tribunals. Without judicial independence, the public cannot and the public will not have confidence in the justice system. Judicial independence, therefore, is not a prerogative or a privilege in the interest of judges, but rather is in the interest of the rule of law and of those seeking and expecting justice. However, and this is an important qualification, independence does not have to mean a lack of accountability. One, and to put it in one sentence, also needs to guard the guardians. This is why, in fact, all modern legal systems provide for independent oversight mechanisms to prevent and eventually sanction abusive conducts or the violation of ethical, statutory, or regulating standards governing judges. These oversight mechanisms are legitimate and effective as long as they are not captured by governments or other groups with the aim of pressurizing judges into doing their bidding under threat of arbitrary disciplinary proceedings or worse, arbitrary criminal proceedings against these judges. As often is the case in life, it is a matter of balance. In this instance, the balance must be struck between the need for accountability and the need for judicial independence. To conclude, the principle of judicial independence is a basic principle of constitutional value in most, if not all, countries, arising from the principle of separation of powers. It constitutes one of the guarantees of a state governed by the rule of law. For society, it is the condition for its confidence in the judicial system. For the litigant, it is the condition for a fair hearing. For members of the judiciary, it is a condition of their legitimacy. If you value equality before the law over the capricious application of the law, if you value the right to a fair trial before an independent court over short trials conducted by kangaroo courts, if you value the rule of law over the arbitrary rule of strong men, you ought to support and defend the principle that judges need to be independent, and especially independent from the executive. Thank you very much. Andrew, the ball is in your court.
Thank you. I'm saying good afternoon, ladies and gentlemen, simply because it's the afternoon where I am. I don't know what time of day it is where you are, but welcome to you, whatever time of day it is where you are. My task today is to put forward an argument or two as to why the judiciary should not be independent of government. And I would like to start, if I may, by looking at the word independent. Now, I'm speaking to you from Scotland, so my experience is really in relation to the system as it exists here. I expect that it is analogous to the system that exists, that prevails where you are. So I hope you'll forgive my being a little bit parochial and tending to refer to Scotland throughout the course of this submission. As regards independent, we hear a lot about independence in Scotland, and the word, generally speaking, in my view and in my submission, has generally positive connotations. So, for example, fee-paying schools, private schools, like to describe themselves as independent. Scottish National Party, where I am, talks about independence rather than secession or separatism or separation, simply because the word independence has good It has good vibes about it. It sounds like a good thing to strive for. Suggests freedom, and it's seen generally as a good thing. So where there's a motion before you that the judiciary should be independent, that may seem initially like a good thing to you. The motion, however, is not simply that there be an independent judiciary, but that the judiciary should be independent of government, by which I think the motion means independent of our government or your government. If the motion were that our judiciary should be independent of a foreign government, for example, the Russian government, I think it would be hard to argue that the motion should be refused. Equally, if the motion were that the judiciary should be independent of big business or lobby groups or criminals or dishonorable people, then of course it would be hard to oppose it. But the motion is that the judiciary should be independent of our government. Now, I would like to start, if I may, by looking at a situation that existed in Scotland until about 20 years ago, and it concerns the appointment of the judiciary here. At one time in Scotland, sheriffs who do the bulk of the judicial work in Scotland in the sheriff court here, sheriffs were appointed on the recommendation of the Lord Advocate. Sheriffs are appointed, they were then and they still are, they're appointed by the Queen, but on the recommendation of someone else. And until 20 or so years ago, it was on the recommendation of the Lord Advocate, who was and still is the head of the prosecution in Scotland. He heads up what's called the Crown Office, which is essentially like the Crown Prosecution Service in England. So sheriffs were being appointed by another lawyer, in effect. And we ran into a terrible problem with the compliance of this procedure with human rights legislation. And at one time we had in Scotland what were called temporary sheriffs, who were appointed by the Lord Advocate, in essence, for temporary periods, and subject to his approval, their commission was renewed. And the concern was that those judges, those temporary sheriffs, might be concerned about issuing decisions which would not find favour with the Lord Advocate. And it was held in a couple of cases that that procedure was not compliant with Article 6 of the European Convention on Human Rights, which guarantees the right to a fair trial. So we had a situation there where lawyers were appointing other lawyers, sheriffs, judges. There was no involvement from outside. It was very insular, it was very unhealthy, and it didn't work. And it enabled the Lord Advocate to promote people that he wanted to promote without any outside involvement. So the result was there was an Act of Parliament passed which brought about a reform of the system to bring in other persons. Lawyers were taken out in the main. They're still involved to some extent, but there's an important lay element now in what's called the Judicial Appointments Board. And they are required to promote concepts, principles such as diversity and equality. In my view, you have a greater government involvement there, insofar as the government realised it had to change the law, brought in non-lawyers, and we now have a more transparent and even-handed way in which our judges, our sheriffs are appointed. Now, you might say, well, that compromises the independence of the judiciary and the lawyers from the government. In my view, it probably did, and it was a good thing that it happened, because the system that we have now, I think, is a better system. So going back to the motion and the question of independence, let's look at the situation once the sheriff has been appointed and how he or she actually operates as a sheriff. Well, I would ask you to consider a less benign interpretation of independence, because although Professor Pech said that independence didn't mean a lack of accountability, I would argue that there is a great risk of lack of accountability and a lack of your having to answer for your decisions and your actions. And this is of paramount importance because it's not so bad being unaccountable if you don't have a great deal of power. You can act irresponsibly, you can act incompetently, and no one else suffers as a result of that. However, the judiciary has enormous power, and in my submission, it is risky if that power can be exercised without accountability, without proper accountability to others. I would like to ask you to consider the day-to-day business in the court. This is what I'm familiar with. A great deal of the work I do in the courts is mundane. It's not spectacular. It doesn't make the newspapers. The fact of the matter, however, is, ladies and gentlemen, that most work that goes on in the courts is unremarkable. It doesn't attract attention. By definition, the landmark cases on constitutional issues and so on, matters of considerable principle and importance, they are very few and far between. For every case in which the court's required to scrutinise whether a Prime Minister has lawfully prorogued Parliament or asked Her Majesty to prorogue Parliament, for every one of those cases, there's probably 100 or 1,000 other cases that never make the papers because they're not considered important enough. However, in my submission, they are of considerable importance. If you are in the middle of one of these cases that never makes the papers, it's of paramount importance to you. So, for example, there are numerous child welfare hearings, which are hearings designed, as the term indicates, to look after the interests of children in terms of making court orders relating to families. These go on day after day in the courts, and they never make the newspapers, but they are obviously of considerable importance to those who are involved. And these cases are decided by judges and by sheriffs. So the fact is that these individuals, sheriffs and judges, have enormous power and potential to affect the lives of countless of our citizens. So, despite the fact that most of the work that goes on in the court is unremarkable, cumulatively, it's of paramount importance that it's undertaken by those who are accountable for their actions. In small value cases, I would suggest that it's important that judges correctly decide these cases and do it on a principled and ethical basis. Because cumulatively they are of considerable importance. And in addition, ladies and gentlemen, we don't want a situation where individuals feel that they have not been listened to by the courts and they go away feeling rude. I have undertaken numerous cases in which my client has been inarticulate, perhaps uneducated, and to that extent vulnerable, and yet has felt that the system did not properly listen to him or her. And in that situation, the person feels as if they were not taken too seriously, and the outcome of the case reflected that. My point is, ladies and gentlemen, that there can be very subtle forms of discrimination practiced by the judiciary. Not in a malevolent way. It's not malicious. It's the kind of minor or kind of subtle discrimination that we all probably exercise. But we do see it in my submission in the courts. And for this reason, it's critical, I would suggest, that there should be some degree of accountability. There should be some degree of scrutiny by an outside body. And I would suggest that the best outside body to undertake the scrutiny is the government itself. Now, I've talked about the power that judges have in what one would describe as minor value or unremarkable cases. However, if we're kind of being, I don't know, if we're having an oversight of the powers of judges, we have to consider just how powerful judges are. Judges can take your children away from you. They can put you out of your house. They can make you bankrupt. They can confiscate your property. They can fine you thousands of pounds, and they can send you to prison. They've got enormous power. And I would ask you to consider, is it a good thing that anybody can exercise all these powers over you and me and our friends and family without proper accountability? In other words, without having to explain or justify their decisions. Now, Professor Pech talked about oversight mechanisms, which I understand that's maybe something that one would regard as a sufficient safeguard. Oversight mechanisms are a check on the power of the judiciary. But I would say to you that in practice, the oversight mechanisms are not a panacea at all. They're not a complete remedy and a complete answer. I mean, if I can turn firstly to the question of appeals, you might say, well, if a judge gets it wrong, you can appeal him or her or them. There's a number of points I would make about that. The first one is that some judges cannot be appealed. For example, the justices of the United Kingdom Supreme Court cannot be appealed. I would say, secondly, that many decisions in the Sheriff Court at a fairly low level in the judicial system in Scotland cannot be appealed. There are numerous rules and laws and regulations where it is stated that the decision of the court is final. Can't appeal those. In addition, there's a numerous types of cases where you cannot appeal without the permission of the judge or the sheriff who granted the decision against which you wish to appeal, which you might think sounds a bit odd, but that's the law in Scotland. You need the permission of the sheriff in order that you can appeal him or her. And in my experience, you rarely get that permission. And this can be the situation in a number of very important types of decision. For example, interim orders in cases involving children are generally not appealable without the permission of the sheriff. And if the sheriff doesn't give you permission, you've had it. That's as far as it goes. In addition, ladies and gentlemen, there's a great number of cases or decisions that can be made by sheriffs which are not in practice capable of being successfully appealed. For example, decisions concerning expenses, a great many decisions involving criminal sentencing, decisions that concern an exercise of discretion. Sheriffs have considerable latitude in how they exercise discretion, and as long as they don't go out with the parameters, wide parameters, whereby they can exercise their discretion, the decisions are untouchable. It's a very high test to appeal an exercise of discretion. In addition, sheriffs day in, day out assess somebody's credibility or reliability. In other words, whether if you're in the witness box, whether you should be believed or whether your testimony should be relied upon. They do that on the basis of assessing your demeanor, your manner, the way in which you speak, your appearance, all these little subtle factors which a sheriff will use in order to assess your credibility. In practice, a sheriff's exercise of that judgment is pretty well unappealable, in my experience. So there's that. Next point I would make, appealing a decision is a very expensive business a lot of the time. It's costly to appeal cases, particularly because if you appeal a sheriff, you may find yourself in front of a bench of 3 appeal sheriffs. And at this stage in the hierarchy, as it were, the expenses can be very considerable. And if you lose, not only will you be paying your own expenses, you'll be paying your opponent's expenses. A lot of people are deterred from appealing because of these costs and these risks. In addition, if you appeal, you are, of course, appealing to other members of the judiciary. You're not appealing out with the judiciary. And in my experience, appeal courts will proceed on the basis, and I can understand why they do this, that the lower court got it right, and the onus, the burden, if you like, is always on the appellant, the person appealing, to show that there was a mistake in the lower court. And lastly, a reason why an appeal mechanism is not sufficient is that decisions can be made and which will stand whilst an appeal procedure is ongoing. For example, in relation to cases involving children. I well remember a case in which I was involved where a 14-year-old girl was placed with her father, who was a completely unsuitable individual. The decision to place her there was made by a sheriff. We sought leave to appeal. That was refused. Case went to proof. Evidence heard. This was about a year later. At that stage, the girl had been with her father for so long that the court took the view that it wouldn't be in her interests to move her elsewhere to her mother. But it would have been almost certainly the case that had that appeal been allowed at the time the order was made, that the sheriff would have been overturned, but he would not grant leave to appeal. And in my view at the time, and it still is my view, is that considerable damage was done to that wee girl. Dropped out of school, who got pregnant underage, who was drinking, who was taking drugs. Her life was diminished. Her quality of life was severely diminished. Her prospects were damaged as a result of a bad decision that was made by the court and which was unappealable at the time that it mattered. So appeals are there. The opportunity to appeal may be there. My submission, it's not enough. Another oversight mechanism that we have in Scotland is whereby you can actually complain about a sheriff's conduct or his or her behaviour. There is a mechanism by which the First Minister here can constitute a tribunal to decide whether the sheriff or the judge is unfit to hold the office due to inability, neglect of duty, or misbehaviour. So the mechanism is there. It is hardly ever used. It's only ever been used in very, very few cases. And it's designed, in my submission, to deal with extreme situations where you have someone who just isn't up to the job. It doesn't deal with the everyday errors and misjudgments that are made in courts all the time. So although that mechanism is there, my view, my submission would be it's not enough. Even taken with the ability to appeal, it's not enough. My submission to you would be that the only effective way of having an accountable judiciary is to have supervision from out with the judiciary itself. And the best supervising body must surely be our own government. Given that in a democracy, the government is elected by you and by me, it's accountable to us, it protects us, it ought to reflect our will. Its legitimacy derives from having been elected by us. By contrast, of course, the judiciary is entirely unelected. And this is an important point, ladies and gentlemen, it is practically impossible to get rid of a judge or a sheriff. If you don't like your MP or MSP, you can vote him out, vote him or her out at the next election. You can take steps to deal with that. You can't sack a judge. You cannot in practice get rid of sheriffs. And you can't vote them out because they were voted in the first place. So do we really want a situation where the judiciary is, in essence, a law unto itself, unaccountable in the main, and unable to be removed? I don't think that's a healthy situation, and it's not one that in my view, would justify saying that the judiciary should be independent from government. Now, I would like to say at this point, ladies and gentlemen, that I don't wish to give the impression that I am, in general, critical of the judiciary in Scotland. It may sound as if I am, if I'm having a go at them. I'm not. I'm not critical of their ability or integrity in general. In my experience, the caliber of sheriff and judge here is high, and the standards that are reserved are high. So I'm not being critical of the judiciary generally, but I am making the point that judges are only human. And someone said that to err is human. I don't know who it was, probably Shakespeare. He's usually the source of most quotes like that. But anyway, someone said that, and it's true. Judges are only human, and humans. And as I've alluded to this already, we all harbour prejudices and preconceptions, which are often based on subtle factors, such as somebody's accent, somebody's appearance, somebody's lack of articulacy. And there can also be blatant forms of prejudice, particularly where I am in the west of Scotland. I once conducted a proof in which the sheriff's bar officer told me that the sheriff didn't like the colour of my client's jumper. And to make that comprehensible to those of you who don't live in the west of Scotland, the colour blue is often associated with Rangers Football Club. The colour green is associated quite often with Celtic Football Club. These two football teams can attract some degree of sectarianism. And the observation made by the bar officer in that case showed me that the sheriff was displaying a degree of sectarian prejudice. So, unfortunately, there is prejudice in all levels of our society and in all professions. And the notion that we should have a completely independent judiciary is all very well if the personnel who take up the positions of the judiciary are all superhuman, all possessing the wisdom of Solomon, all entirely free of prejudice and preconception, and incapable of making mistakes. If they're infallible, it's fine. We can have a system like that. But unfortunately, the system doesn't work like that. I wish it did, but it doesn't. So, for all these reasons, I would submit to you that the motion should be rejected. The judiciary cannot be entirely unaccountable. It's unreasonable. And in a democracy, the best overseer, if you like, of judicial integrity and behaviour should be the people's own representatives in the form of the government that we elect to represent us, to look after our interests. It is the most appropriate check on the power of the judiciary in a democracy. And we need a check, given the enormous power that's exercised by the judiciary. I mean, ultimately, they'll decide, as I say, whether Parliament can be prorogued. They've got enormous power in huge constitutional matters, but also, as I've also indicated, in minor, or you would think minor cases throughout the courts involving children and people's rights, people's liberty, and so on. So there needs to be a check on that power, and the government is the best placed body to exercise that check. So I would invite you to reject the motion that the judiciary be independent of government. Thank you.
Gentlemen, thank you very much. Very much appreciate both points of view. Before moving on to take questions and answers from the students, I wonder if you'd like to spend just a couple of minutes discussing the points raised by the other just to enable the students to get your positions, whether they be your real positions or otherwise, so they can understand what they should be looking at doing when they debate their cases in a few weeks' time.
Yes, I mean, Andrew has raised the powerful usual counter-arguments to essentially the claim of the principle of judicial independence. But obviously, I would have counter-arguments, but I would say, yes, I would agree that diversity of the judicial branch is an issue, including in the UK. So for the judiciary to be legitimate and be obeyed, judges themselves, it's important that they represent society at large. So there is a diversity issue in a lot of countries. Andrew has also essentially raised the issue regarding what I view as not directly connected to judicial independence, but connected to the rule of law, which is essentially access to justice. And I would also agree with Andrew that we have a major access to justice issues in the UK, but that's also true of most countries. Legal proceedings tend to be expensive, protracted, and quite often, even though we have the principle of equality of arms on the books in practical terms, quite often parties do not necessarily have the same economic means to fight their legal claims. And in countries where there is no legal aid or very little legal aid, then access to justice is an issue. Then there is the effectiveness of judicial remedies, which Andrew has also raised, and which is also an issue I would agree with. However, I would not connect it to judicial independence as such. You can have an independent judicial system with very effective legal remedies. The way the right of appeal is organized in a specific country, if it's not working, then it can be changed. It doesn't necessarily mean that judicial independence as such is the problem. Accountability is another powerful argument raised by Andrew. I've explained, obviously, that it's important that we need to guard the guardians, to borrow from an old Latin expression. But this is true, in fact, of elected officials. We need to guard, we need to have powers and counter powers. We need to have checks and balances. Then the issue becomes, how do you define this accountability oversight mechanisms? I have personally nothing against involving members of the public at large. What I would strongly object to is having accountability mechanisms controlled by the government and or the legislative body. So it's all about how do you design sound, reasonable, independent oversight mechanisms to review the judiciary or the behavior of judges. So Andrew did also raise the argument that you cannot remove judges, but you can discipline them. And in fact, in a lot of systems, you can actually impeach judges. Yes, it's very difficult to do so, but for good reasons. We don't want judges to be the mercy of some impeachment on the basis of a capricious interpretation of the law or just abusive litigants. So yes, accountability is an issue, is a good, powerful counter-argument, I would say, but it doesn't mean that judicial independence in and of itself should not be protected and defended. The last point I would make regards the most powerful, I think, counter-argument raised by Andrew, which is democratic legitimacy. Then, obviously, the counter-argument is quite often, whenever we discuss judicial independence, quite often people raise the issue of the fact that judges are not normally elected, and therefore their democratic legitimacy would be less so than democratically elected MPs, for instance, or democratically elected executive members. Just one factual qualification in this respect is that in some countries, actually, judges, local judges, are elected, but not usually judges working for the national government or the federal state. That being said, in most countries, judges are not elected. Why? For good reasons. We describe judges, or judiciary, quite often as a counter-majoritarian institution. So that's a bit of a technical concept. But judges, like central banks, for instance, we have agreed in a number of democratic countries that it's good to have non-elected checks and balances to actually make sure that the elected branches of the government are subject to a number of norms and constraints which are not dependent on a short-term election cycle. So there are good reasons for an independent judiciary. And remember that the fact that they're not democratically elected should not make you forget that the judiciary is the least powerful branch. So this is why possibly I would disagree with Andrew, which has presented the judiciary in Scotland as very powerful. But I would say in the UK, broadly speaking, which is a country subject to parliamentary sovereignty, in a sense, at the end of the day, judicial independence is only possible to the extent that he has been allowed by the parliament. So the judiciary is not the most powerful branch. In fact, it has been described in the US as the least dangerous branch. So if anything, I'd be more worried about abuse of power from the executive acting de concert with the legislature. And this is my last factual point. In fact, even though I have mentioned the principle of separation of powers, so technically, according to well-established according to this well-established principle of separation of power, we need to essentially allocate powers between the executive, legislative branch and the judicial branch. Sadly, in modern times, essentially, there is virtually no separation between the executive power and the legislative power. In the UK, this is quite striking. As soon as you have a very strong majority in the parliament, essentially the government is unaccountable to the parliament because essentially it's the same ruling party dominating both the executive branch and the legislative branch. In this particular constellation, you want a very powerful, independent, unelected judicial branch. Otherwise, then you leave the application law at the mercy of the electoral cycle. And when you say elections, remember, elections in a democracy means the rule of the majority, but this is not the rule of law. The rule of law means the application of rules by independent actors. Otherwise, you're going to end up, if a judge is elected, then possibly the temptation would be to do what the majority wants, regardless of whether you're guilty or innocent. Think about criminal trials especially. Do we really want judges to be elected by the majority and judges then to apply criminal law based on whatever the majority wants? Think of yourself, put yourself in the shoes of a member of a non-majority group. Would you really want to have elected judges looking into possible criminal charges brought against you? But the same applies to civil proceedings. If you want to have a fair, essentially, trial, if you want to be fairly treated, you want non-elected judges applying the rule of law. So this is my reaction on some of the points raised by Andrew.
Andrew, before you respond, if you don't mind, Professor Laurent has made a reference to judges in Poland. In actual fact, we actually have one who's on the system today, Dorota, who's desperate that I don't ask her to speak, but I'm sure she will do, to give her point of view. And then, Andrew, would you mind thereafter giving your views? So, Dorota, could I ask you to maybe switch your microphone on? You don't have to put your camera on if you don't want to, but just to pass us your comments.
I was unmuted and it's not on the screen.
Hello.
Irene, if you please mute your speaker, your microphone, please. Thank you. Dorota, you coming on? I know you're about because you were speaking to me just 2 seconds ago. Right, perhaps she's finding her microphone. So, Andrew, sorry about this. Would you mind responding? And hopefully Dorota will come on in a moment or two.
Well, what I would say is that Laurent is correct in emphasising that we can't have judges pandering to popular opinion, which I think is the gist of one of the arguments that was made there, and that they have to be kind of above that. And we don't want the kind of tribunals that we had during the French Revolution or the Soviet Revolution and so on, where it's just mob rule, kind of masquerading as a court system. Nobody wants that. But I would just go back to saying that judges are enormously powerful. Not just here, but in America, in the US, for example, the Supreme Court in the United States essentially makes law. It decides that racial discrimination is unlawful, that abortion prohibitions on abortion is unconstitutional, that in an argument, for example, with the Watergate case, the argument where President Nixon basically thought he could withhold evidence because he thought that's what he wanted to do, and he was overruled by the Supreme Court there. Well, there's numerous cases where the courts exercise huge power, and the problem is, in my submission, is that it's power being exercised by unelected officials, and there has to be a proper check on that in a democracy. I think there is a difference between a democracy and somewhere like Russia, for example, where we don't want Mr. Putin influencing judges, but in a country like ours, in the United Kingdom, I don't think there's anything wrong with responsible government exercising some scrutiny over the activities, the actions of the judiciary. And I don't think that if the judges have done anything wrong, they have anything to worry about. Everyone should be able to explain decisions that he or she has made. And if he or she can't do that, there's obviously something that needs to be looked at. So I suppose it's all a question of a balance of power. And the issue, I suppose, is whether the balance is correct at the present time. I don't think it's a good thing for the judiciary to be entirely independent of government. And that's why I'm arguing that this motion should not be granted.
Thank you very much. Now, see, Dorota is actually just coming back online. So if you can just bear with me a moment or two. Oh, no, she's saying her microphone won't turn on. Just bear with us a moment or two. Right, while we wait for Dorota to fix that, I wonder if we should open up now to questions from the students. Now, we ask you don't use your microphone just because it becomes too noisy. There's too many of you on. So would you mind typing your questions in the public chat? It would be useful if you wish to hear from a particular speaker to start with their name, which is on your screens, and they will then answer to the best of their ability. While you guys are all typing away, because I can see there's quite a few of you, you can ask questions in relation to the previous two lectures you've had that maybe weren't covered today, but try and get the points of view of either Laurent or Andrew as to what their views are on what has been said in the previous two lectures. So, Andrew, I think you've got the first question from Nancy, and straight after that, Professor Laurent, you've got a question there from Pablo.
Yeah, I've got a question there from Nancy referring to the fact that the Nazis were democratically elected, which of course is correct. Well, what I would say, Nancy, is that that situation, I think, was something of an aberration. Using Nazi Germany as an example of how an elected government isn't necessarily the best arbiter of justice or principles. I understand that you can do that, but for every Nazi Germany, there are countless democracies where the government, I would suggest, does have a legitimate interest and a legitimate reason for holding the judiciary accountable. I agree that Nazi Germany, or you might say apartheid South Africa, there are always these examples where you can try and turn the thing on its head. But in nearly all cases, I think it holds true that the government, a democratically elected government, it does have a legitimate interest and a legitimate right to hold the judiciary to account. So that's my response to that question.
So yeah, it's a very interesting question, Nancy, and I'll answer the question by Pablo in a minute. But I just wanted to say that in Europe, this is not true of the UK for historical reasons, but post-World War II, the judicial independence was enshrined in national constitutions, with constitutional review also introduced for the first time, exactly for the reasons you have essentially mentioned in your question or in your comment, Nancy, in that we have a judiciary to prevent essentially those who are against the rule of law, against a democratic form of government, to gain power through elections and then completely corrupt democracy and the rule of law once they get elected once. So this is why we have independent judiciaries, and this is why, especially in continental Europe, we have constitutional courts with the power, the jurisdiction to strike down national legislation. The UK, different history, so I'm not going to get into it, but essentially this is one of the reasons why judicial independence has been enshrined in national constitutions in Europe, and why we didn't want judges to be elected. Actually, Andrew mentioned the good example of the French Revolution. In France, they tried elected judges. It didn't work. Therefore, we went back to professional judges. To be selected after university studies. Pablo, so you asked me to explain the rule of the majority is not the rule of law. And indeed, essentially what I meant to say is that, first of all, democracy should not be understood as the rule of the majority. The proper democracy is a system of government, yes, where essentially a majority in parliament can adopt laws, but these laws must be in compliance with the national constitution if there is one. And also this national legislation must always take into account the rights of minorities, especially human rights. And to make sure that the majority of the day is not going to abuse its legislative power, we have an independent judiciary in the country and in Europe, but also in most continents. You have also, post-World War II, you've seen the establishment of supranational courts, something we didn't really have time to mention today. But in fact, especially regarding human rights in Europe, you have the European Court of Human Rights, which is an additional check, essentially, not only on authorities like the national governments and national parliaments, but also on national judiciaries. So this is part of making sure that the national judges do not abuse their power. You have an extra supranational check. So essentially, my point, Pablo, was to say that democracy is more than the rule of the majority, and democracy must be essentially subject to rule of law principles. This is very much what we have learned from essentially the 1930s in Europe. You cannot have democracy without the rule of law, otherwise what you're going to end up with is potentially the rule of the mob rather than the rule of a proper lawful majority. So essentially, when you think about judicial independence, you have to remember that judicial independence is part of a broader system Remember the principle of separation of power. We want to have an executive, we want to have a legislative, and we want to have a judicial branch working together, making sure that one doesn't gain too much power over the other two. This is essentially separation of powers, but also can be understood as balance of powers. What history has taught us is that we want to make sure that we have a number of functions separated between these three powers. If one is too powerful, then this is the road to troubles. So I hope I have and I've explained my point a bit better. Perhaps I should just, my last point is if you want to know, if you want to understand better how the rule of law does and must constrain the rule of the majority, I can refer you to a very good study, possibly too challenging for if you are between the age of 14 or 18. But there is a body known as the Venice Commission in Europe, which has published a rule of law index. So explaining essentially in this index, you can see some relatively easy to understand explanations as regards how the rule of law must essentially constrain the adoption of legislation in a democratic government, democratic system based on the rule of law. So this might be of interest. I can share the link with the organizers this evening if they want to share with the students later. It's called the Rule of Law Index by the Venice Commission, which is a body of the Council of Europe. And the next question is for you, Andrew. Sorry, I spoke for quite some time.
Yes. Maruk here is asking about, hang on, where's my, about interference with the judiciary. I think I said at the outset that I don't think there should be interference with the judiciary by, for example, foreign powers or lobby groups or press barons or big business or any of these kind of interests. I wouldn't describe scrutiny by the elected government as interference. I think that the government has a legitimate interest in undertaking that kind of scrutiny. And to characterize that as interference, I don't think is an appropriate use of the word. So what I'm saying is it wouldn't be interfering with the judiciary to have proper government oversight of what happens, of what they do. So that's really my answer to that. I see that Jennifer has asked a question about, let me see, whether we can truly have an independent judiciary. Well, in my view, no, we can't. And inevitably, the opinions, the politics of individual judges will inform their decisions. That's why in the US Supreme Court, the president wants judges who will reflect his, and it is always his because there haven't been any female presidents, his own views on various issues. And bear in mind as well that, as far as I'm aware, the justices of the US Supreme Court have a lifetime appointment. They don't have to retire. So they're there. They can be there for decades, exercising enormous power. And essentially, they are political appointments. And it's no coincidence that Donald Trump will appoint someone who reflects his views. Democrats will do the same. So, yeah, I don't think that you can have a truly independent judiciary, which makes it, in my view, all the more important that there be outside scrutiny of the decisions that they make.
So I will have to disagree, obviously, here. In fact, the US is a very good example of the worst possible way of combining democratic legitimation and independent judiciary. If you compare actually the way the UK Supreme Court is appointed to the way the US Supreme Court is appointed, then you understand that possibly, or I would argue, that the reputation of the UK Supreme Court as an independent judicial body is higher than the reputation of the US Supreme Court. Why is the reputation of the US Supreme Court as an independent court suffered? Because of the politicization of the appointment of the justices of the US Supreme Court. And in fact, this is my very point. Sometimes, and I mean, you can argue in most cases, the more you introduce or the more you give the possibility of political actors to get involved in the appointment of judges, the more you undermine the legitimacy of the judiciary. This is why this is in fact raising the issue of appointment of justices. In my view, the best system is a system where judges are appointed based on professional qualifications. So essentially based on either their length of practice as a lawyer before, and then followed by independent appointment procedures, which involve other senior judges, and certainly exclude as much as possible political actors to avoid a situation where essentially in the US you are picked for reasons of linked to the political ideology or suspected political ideology of justices of the US Supreme Court. So the US, in fact, could be used as a good example why, in fact, appointment procedures must be insulated from politics. And this is why, in this respect, I think the situation is much healthier in the UK, and yet surprisingly, or perhaps not surprisingly, post-Brexit, now we're talking about making the appointment of UK Supreme Court judges more responsive to the Parliament, which is, I think, would be the worst possible evolution we could see in the UK, because it would actually undermine the reputation, legitimacy, and independence of the UK Supreme Court. This is a good example, actually, where democratic concerns have actually undermined the functioning and authority of what was once a prestigious, possibly the most prestigious Supreme Court in the world. Very good question, Jennifer.
Chaps are running out of time, so if you do have a question, can we have it within the next few seconds? Otherwise, I'll have to bring this debate to a close. So you can just wait a moment or two just see if there's any final questions. I do see someone is typing, and we can go from there. Just a moment or two.
Next time, Andrew, let's have a debate in Scotland, because I've never been to Scotland.
Really?
No, never had the chance.
Well, you should visit once this lockdown nonsense is over.
I would love to. I've been to Wales, I've been to Ireland, Northern Ireland, obviously England, but Scotland is the missing country.
You better hurry up before they put a border up.
I have a French passport, so I think I'm safe.
That's good.
There we go. I think we've got the last question coming in now, gentlemen. If we could quickly address that.
I'm just reading the question. I think it's more of a comment than a question. So I guess, yes, the point being made, which is a good point, is that, yes, the judiciary can be a tool of essentially exploitation. This is true. There is a dark side sometimes to the judiciary. In fact, think about Nazi Germany or think about South Africa apartheid days, obviously, then judges, or think about Putin's Russia. Judiciary can actually be used by the ruling party to actually conduct the ruling party's business. Andrew mentioned show trials, I think, during his presentation. And I mentioned the expression of kangaroo courts. Just look it up. Essentially, look for examples of show trials in history, or look for examples of so-called kangaroo courts. And yes, the point you being made by Sisypho is correct. Sometimes the judiciary can be a tool of exploitation, arbitrary measures. But in a system governed by the rule of law, this would not happen. So this is only happening in systems which are not governed by the rule of law. So that would be my final comment.
I think that's a very interesting question in light of what was said in the weeks just gone by. And Andrew will know the figures much better than I. But it's not just powerful men, it is the men that went primarily to private schools. And in fact, kind of what the figures were from the weeks gone by, the number that went to either Cambridge or Oxford universities, and perhaps a little bit out of touch with the working man. I'm not sure if that's what he was trying to suggest, but I know that was certainly raised in the weeks gone by.
Well, I do think that the system that we had in Scotland until 20 years ago, it did tend to lend itself to a degree of inertia in terms of bringing in outsiders, newcomers, fresh blood. It was all a wee bit incestuous to some degree, which I think is one of the reasons they decided it wasn't a good system. Lawyers, they need to be able to, and I count myself in this, we need to be able to explain ourselves to those who are not lawyers. We could be a little bit insular, and it's not healthy. And I think the same applies with the judiciary.
I think we are actually now well over time. So can I say, gentlemen, thank you very much. Professor Laurent, I noticed your interest in coming to Scotland. You should never say that when I'm online, as we're always desperate to bring in judges and others with the many programs that we run up here in Scotland. And I'm sure myself and Andrew will twist your arm at some point to get you to come and preside over one of the many trials.
Please
do. So I'm afraid we are out of time for questions. So gentlemen, can I thank you both very much for a very informed debate. Again, stretching the bounds of what the kids will be used to listening to, and helping them with their debates in the coming weeks. So thank you very much indeed.
Thank you very much for having us.
Yeah, thank you very much. I wonder if I could just say at the end that this is a debate, and the views that I've expressed don't necessarily reflect my real views, just to make that clear.
Yeah, Andrew, you had a difficult case to argue. Just to make clear that what I have argued, I do believe in it, but so that was easier for me to defend the submission the way I did.
It's okay. I'll remove the disclaimer at the end of the recording. All right, gentlemen. Thank you very much. Good night.
Thank you. Bye-bye.
Right, thank you.